The moderator for the session is Max Schatzenbach, who is a professor here at Northwestern Law School. He's one of the leading empiricists in studying the tort system. Max is going to moderate our session now on litigiousness in the disappearing trial.
And as I understand the format, what we're going to do is each speaker is going to have 10 minutes. We'll do all three speakers in a row, and then I'm going to turn it over to the commentators to make comments, general comments on all the papers, any of the papers, one of the papers, however they choose to do it. And after that, we'll throw it open to the audience. So the first paper is by Tonja and Jacobi, and it's entitled Explaining American Litigiousness, or Not.
Well, thank you very much for having me. I'm particularly pleased to be here since I'm a little bit of an interloper. This isn't really my primary field. Let's just say that of your first two speakers, Marshall and I, we still have above average knowledge of torts, but we won't talk about the distribution of that knowledge between your first two speakers. What I'd like to do is present a theory of causes of litigiousness that might be a little different to those that most people think of. Most people think of particularly the legal regimes and how that affects litigation levels. And what I'd like to suggest is that we need to explain why there are those different legal regimes as well, that's endogenous. Things like different costs rules, for example, need to be explained as well as litigation levels. Be that comparative litigation levels, either sort of America versus the rest of the world, or even variation within states, for example. So I'm going to talk a little bit about what can cause that variation, and I'm going to present some data that I do at the state level, but the theory can be applied either at the national level or the state level. So I like to think of litigiousness as a choice to choose. A choice to act through litigation to resolve a dispute rather than through some other mechanism. And so what I'm really interested in is the extent to which there's a substitution effect between legislation and litigation in particular. So what I'd like to do is present to you a theory of political causes of litigiousness, namely how divided political structure, fragmented political structure leads to higher litigation levels. And the essential idea is that the more gridlock there is created by more veto players at among the electoral branches trying to pass legislative policy, the more difficult it is to pass either legislation in the first place or detailed legislation. And then people instead turn to the courts to provide sort of that resolution of conflict. What I'd also like to talk about is some of the economic causes. This is still very much something I'm sort of developing the theory of, and so I'd very much like people's feedback as to what they think about both the sort of the theory that I have, the sort of rough theory of the economic causes, and also of my results, of my empirical results. So people talk about, I should just say that in terms of substitution effects, people talk about substitution between legislation and sort of administrative action regulation, and I recognize that, and I'm trying to look at sort of a different effect here. And whether you see legislation as sort of a resolution of social conflicts or pork for interest groups or whatever your theory is, I think that that we can still analyze this question. So the essential theory is that in terms of the political factors, that the more there is gridlock among the electoral branches, the harder it is to check the judiciary, the more leeway the judiciary has to act. And also at the same time, the greater demand there is for the judiciary to act because the electoral branches aren't fulfilling that role, aren't meeting that demand. And then finally, I want to talk about economic growth. And economic growth is, the economy's relationship to litigation is typically seen as one of litigation as this transaction cost on the economy, and it slows it down. Whereas I tend to think of litigation, and this isn't, as I've said, this isn't sort of highly theorized, but litigation as part of the way the economy operates. It's how America does its business in a lot of ways, and it's a product of arguably economic growth. And so, contrary to the idea that there's this huge litigation explosion that we need to be really concerned about, I would think that there's sort of that litigation is going to come along with strong economic growth. So let me briefly just talk about political factors. There are all these different sorts of political division, bicameralism, and independent presidency. All these sorts of things provide additional vetoes on the political process. This is well explored elsewhere, and my argument is essentially that the larger the region between the executive and Congress, for example, or any legislature, the larger here is effectively the gridlock region and gives greater movement for the judiciary to act, and also creates greater demand if the bigger the region in which the electoral players can't operate, the harder it is to pass legislation that's going to satisfy the demand for social conflict resolution. And so I have these hypotheses that judicial activity is going to increase with various forms of governmental division, divided government, bicameral division, and depending on the extent of the margin in the House and Senate of the various legislatures. In terms of the economic factors, this is a graph of general filings, general civil filings, and this is the data that I'm going to look at. It's general civil filings over time. So over 25 years, we see this sharp increase over time. But when we look at how the economy's grown at that time, it's grown at a very steady clip as well. And so we see a strong similarity in the slope between these two lines. This is at the state level. This is using what's the equivalent of state GDP. It's called GSP. So filings is the top line, and gross state product is the bottom line. All right. Well, let's actually have a look at. So that's the first impressionistic look at the data, and this suggests that if we try and these, I'm almost hesitant to call these hypotheses. These are sort of gentle theories, I guess I'd say at this point. One is that we're going to have economic growth is going to be strongly correlated with filings when we break it down in a bigger way than just what we saw in the graph. And secondly, that this idea of this time trend, this litigation explosion, are we still going to see that when we actually control for these political and economic factors? And I would suggest not. Okay, so what I did to test this is I created a data set of filings at the state level in 49 states that have bicameral division, that have the potential for governmental division. So I excluded Nebraska. And one thing that should be said is this is very noisy data. This takes all general filings. I'm not just concerned with, for example, tort filings. The idea is that in any area, if there's not going to be able to be comprehensive legislation, that's where we're going to be seeing more litigation. So I'm interested in general civil filings, but I recognize the data is very noisy, but that should work against me. And so my dependent variable is just total number of filings in courts of general jurisdiction. And then my independent variables are these various political division variables, and then gross state product. I also control for population, a time trend, and fixed effects, because there's going to be huge variation, idiosyncratic variation by state. This is a summary of the data. I might just come back to that if people have questions. Here are some of the essential results. We see that divided government, which I've defined in various ways, so here I've defined it as the Senate and the governor being the same, but the House being different, etc. So all 4 permutations of what that governmental division can be, is statistically and I think substantively significant. If you have divided government rather than united government, then you're going to have about 30-odd thousand additional filings in a year, and that translates at the median to about 11%. Gross state product is also statistically significant. This is a typo, that should be 0.058. And I guess what I would say is in terms of whether it's substantively significant, that's an interesting question. So gross state product is in the millions. What this means is that, so this is pretty much a 1-to-1 ratio. So that suggests that, that for an additional $1 million that the state is having produced in terms of gross state product, that's an additional filing. Now, is that a lot? I'm not sure. It suggests that I mean, it's not obviously directly works like this, but a company, if it produced an extra $1 million, then cannot expect an extra filing, if not a lawsuit. If we go back to the summary statistics, a standard deviation in GSP is 151 billion, and that would suggest one standard deviation shift would mean 150,000 extra filings. And I guess what I'm interested in is some of the reactions from people as to whether we think that's substantively significant. I've just started looking at this, and I'm not sure exactly what I think of that at this point in terms of substantive terms. In terms of statistical terms, it's definitely statistically highly significant. You'll note that I put in a linear time trend, and that's not significant at all. In fact, it's even over here, it's not significant and negative, but so basically just not significant at all. I've basically told you that. Similar results, but not quite as impressive results when we look at things like bicameral division, so it's another form of political division. We're still seeing mostly statistically significant results, but the effect is a little bit diminished substantively. One thing, so a couple of caveats. Do I have time for caveats, Matt? Okay. So a couple of things is, one that I can't establish in this is like in any year a change back and forth between united government and divided government. What effect that has. That's something I can't show. But what I would say is we don't necessarily expect to. We're sort of talking here about maybe a litigious culture that builds up over time in areas that are prone to divided government, and so maybe that's the effect that we're seeing, even if we can't see the effect of a switch in any given year. Would that really change how much people are likely to go to the courts? The second problem is that, well, not problem, but sort of area of interest, I guess, is that there's this negative coefficient on the interaction variables, which is also statistically significant between the economic and political factors, and there could be a couple of different reasons for this. One, I thought of two, and I had Ronan suggested another one to me just yesterday. So, and something I have to think about is, well, there could be this sort of there could be a log rolling sort of explanation that it is possible to overcome the difficulties of divided government, and the more money you have, the easier it is to give pork and overcome those difficulties. So that might explain why the effect of on filings goes down. The political effect on filings goes down when GSP is higher. Or it could be a jurisdictional thing. It doesn't apply to wealthy states, but I can't really see why that would be the case. And then the suggestion that was just recently made to me was is the sort of reverse, that GSP might be having less effect depending on whether it's divided or united government. And I have to think about why that might be the case. What I did is I tried to do a sort of, now it's time to go. Okay, well, I'll just say that I tried to sort of test for this, and there's not much support for it. So perhaps there's some other explanations. So this is sort of, it's very, high level data, like it's very general, noisy, high level data. So there's obviously a lot that's covered in this that is not what I'm trying to get at, but I think that counts in my favor because we're still seeing an effect despite all this noise, but I'm sort of trying to get at a very broad theory of overall structural causes here, and I hope that at least I've given you something of interest to think about that. I'll stop there.
Next, I believe we have it's a joint paper with Paul Brace, who's a the Clarence L. Carter Professor at Rice University in Political Science, and Jeff Yates, who's Associate Professor at University of Georgia. And my understanding is Jeff is going to do the presentation?
I'm not Paul Brace.
Oh, I'm sorry.
I'm not Paul Brace.
You're not Paul Brace. Okay.
Just want to make that clear.
So with that disclaimer, he's going to talk to us about whether or not institutions really matter, with particular attention, I guess, to the election of judges.
Again, I'm Jeff Yates, along with Paul Brace and Holly Tankersley. We're looking at litigation in America, American states, and tort litigation specifically. Now, we're going to briefly trace some of the debates, very briefly, given our time constraints, and then some of the previous literature, and then launch right into our primary research question, which is what effect do judicial institutions and political environment have on tort litigation in the states? Now, we bring to bear 20 years worth of data in 10 states to answer this question from 1976 to 1995. In the end, we find that judicial institutional structures interact with ideological environments to shape what the tort litigation rates in a state look like. Now, Justice Warren Burger's comment highlights, of course, the existing debate over concerns that Americans are increasingly litigious. And of course, this has a lot of related debates within it, its effects on the economy versus its resultant consumer protections. Is it higher now than it has been in other times in America? Is it distinguishable from other jurisdictions in other countries, and so forth? Measuring apples and apples is very important. Now, a lot of the previous research in this area has examined litigation rates over time, provided very good descriptive analysis, and looked at trends to decide some of these issues, or at least provide insight to some of these issues. However, few have endeavored to provide a systematic and theoretical explanation as to what drives people to litigate, what makes one state have a higher litigation rate than another state. And that's what we attempt to do here today. Now, most of the research that has tried to do this has looked at two basic perspectives: political culture theory, which assesses how people view government and society and the world and their place in it, and then also social development theory, which focuses on the factors happening around your life, your environment. Do you have a population-dense area, a lot of people living around each other? You live in the country. Things like that, all those things that might affect you and cause you to litigate more likely. Recent studies have also looked at legal and policy aspects, such as tort reform, public policies in the states. It might make you less likely to litigate because it's handled administratively, like welfare systems and so forth. Now, in addressing the previous literature, we have three basic claims from the puzzles that remain as opposed to why people litigate in the states. Our first is that litigants' certainty about potential outcomes encourages settlement over litigation. In other words, where potential litigants have an idea as to how it's going to come out in court, they tend to settle. When there's some misunderstanding or uncertainty about how it's going to come out, they go to court. We follow that up with some institutional structures increase certainty and reduce litigation, so the way a thing is set up, a court system is set up, can affect this uncertainty or certainty. And then finally, the influence of these institutional structures is going to be conditional upon the ideological environment in which these courts work. Now, we draw upon our certainty-uncertainty theory from a classic article by Priest and Klein in the Journal of Legal Studies. In their seminal article, they argue that disputants form perceptions about win probability based upon a number of factors, such as who's going to be the jury, what's my jury pool look like, who is going to be the judge, what are the facts, evidence, strength of evidence, and so forth. Now, when disputants' perceptions on case outcomes converge or are close, they're likely to settle because they have a similar mind as to how it's going to come out. When they have uncertainty or different perceptions, they're likely to litigate. And so what Priest and Klein find is that when things do go to trial, the plaintiff win rate is about 50% because it is kind of a throw-up, and it tends to breed these type of claims going to court. The ones that are more certain settle out. Now, Hansen, in a rather clever application of the priest-inclined selection hypothesis, shows that the effect of judicial institutional structures, and in his case, he's looking at elected versus non-elected judges, affects outcome uncertainty and litigation rates. So the idea here is that elected judges are accountable or dependent upon political forces, including the electorate, and as opposed to independent judges or appointed judges who don't depend upon these political forces, dependent judges, elected judges, are going to have more certainty in their outcomes for disputants because it's not necessarily better per se, but they tend to have fairly predictable outcomes, whereas independent judges, appointed judges have a wider range of choices, aren't dependent upon the electorate, and therefore there's going to be less certainty in their outcomes. And he does find some mixed support for this proposition in his article. Now, in addition to this, we look at a different, or another rather, institutional structural aspect of courts, and that's judicial professionalism. Now, the literature on state courts suggests, and state legislatures and state politics generally suggest, that professionalized institutions tend to provide outcomes that are more beneficent to have-not litigants and so forth, and that these features affect the outputs of these institutions. Within the context of courts, we can think about things like they have better salary, they have better resources and staffing, they're more accessible, efficient, and organized. They have all the hallmarks of bureaucracy, including specialization and value-neutral decision-making is the idea. And lower cost of information, more time to deliberate, means that most of their outcomes are more predictable because of this higher degree of professionalization. And they also provide faster outcomes as well. Now, how does all of this interact with ideology? Well, in tort litigation, we can think about if an outcome is certain, well, it's going to be certain on a certain ideological dimension. It's pretty straightforward that most people, including the parties, presidential candidates, and so forth, think about tort litigation outcomes. If it favors a plaintiff, it's rather liberal in nature, and if it favors a defendant, it's conservative in nature. So we can think about certainty on a dimension of ideology as well. And states have different ideologies, as you can tell, blue state versus red state. This is going to be kind of a compilation of judges, juries, public opinion, and the stigma associated in more conservative states on filing torts. And our claim is that the effect of these institutions that we're talking about, and Hansen looked at in the selection hypothesis, is going to be conditional upon state citizen ideology. And so to recap, our basic claim here is that institutional structures increase certainty and suppress litigation, but this is going to be dependent upon what the ideological climate looks like. And so certainty can have an ideological dimension, especially in tort, and so that certainty is going to fall along this dimension. Now, disputants understand this, not to mention their attorneys, and act accordingly. So the effect of institutional structure is going to be dependent upon the ideological context in which it occurs. Two examples. One, we have a state with, let's say, elected judges, more certainty, professionalized judiciary, more certainty, and a liberal climate. Therefore, you're going to have more litigation. More litigation. Same thing, highly professionalized judiciary, elected judges, certainty, but a conservative climate, you're going to have less litigation because if you bring it, you're going to probably lose. And so the effect is not of certainty is going to depend upon the ideological context. It's essentially an interactive relationship, if we can think of it that way, not the more additive relationship that Hansen looked at or that Priest and Klein might have posited. Now, data and research on this. Again, we bring to bear about 20 years worth of data, and we draw this from the National Center on State Courts. This has been used in a lot of different studies over time. Our dependent variable is state trial court filings, lawsuits for a given year per 100,000 state citizens. And these are the states that we look at. The states are basically chosen on data availability. The idea is that we haven't kept tort litigation rates in that many states over this period of time, and so that's basically what's available. This is what it looks like over time. You can see that there's interesting both variance across states and within states over time from 1975 to 1995. This blip here in Washington is due to a tort filing deadline for tort reform. If you file it before a certain date, you're not subject to the tort reform, so that's why that big spike is there, and we account for that with a dichotomous dummy variable. Now, how do we go about explaining litigation rates? Well, as I had said, these are our basic ideas here: elections, elected judges versus appointed judges, court professionalism, which we put together an index based upon a great amount of data, and then state citizen ideology drawn from Erickson, Wright, and McIver, well-known measure on state citizens' ideology, pretty straightforward. We also consider other relevant considerations. I hesitate to say controls because I think they are really theoretically interesting. I can talk about any of these in much more detail later. We don't have quite enough time to go into all of them, but hopefully the idea is that they account for all of the other relevant concerns that we have. So, on to the results. We have the idea highlighted at the top here that in the additive model we see court professionalism actually yielding more litigation, but we have to think about it interactively. Some other variables come out, as you might expect, the Washington 1986 dummy variable I pointed out earlier. Also things like no-fault systems, auto accidents, and so forth, as well as jury signals. In the interactive model, in which we interact these institutional factors, professionalism and elected versus non-elected, with the state ideological climate, we see a more nuanced view of how this situation works. And I think this is highlighted perhaps better in some graphics that we have. So here we see, for instance, the effect of professionalism on litigation as liberalism changes. State liberalism is at the bottom down here, and the effect is on the right-hand side. And so the idea is that the blue line indicates the effect with the confidence bands around it. And you see that as the state becomes more liberal, you see higher filings where the certainty occurs. So certainty plus liberalism equals higher filings. Now, in similar contexts, we look at the effect of elected judges. And elected judges, essentially, the same situation. The effect of this institutional change, elected equals certainty, is conditional upon the state ideology. And so the idea is as it gets more liberal state and you have elections, you have higher tort filings. These two mesh together to produce more of an incentive to go to court. Okay? And then finally, we have what we call a triple or three-way interaction in which we can see the effects of court professionalism in both contexts, elected states and non-elected states. And so you can see that in the elected states, there's statistical significance, and in fact, it's a steeper slope or greater, stronger relationship than in the non-elected states, although it is still statistically significant. And so that gives us these ideas of how this conditional relationship works and how it is very important to think about political context when thinking about these factors. Now, to conclude, certainty about litigation outcomes encourages settlement, and institutional characteristics can facilitate certainty, right in accord with Priest and Klein's basic selection hypothesis. However, certainty can have an ideological dimension that is influenced by the political environment. So if an outcome is going to be certain, well, it's going to be certain in tort at least, either liberal, plaintiff-oriented, or conservative, defendant-oriented. So what we're saying is that explaining the nature of litigant decision-making requires a consideration of the institutional and political context. We have to think about these things and thinking about why people are more likely to file lawsuits in one state relative to another state. Not to mention all those other important control variables that we considered as well. So in final point, understanding the dynamics of litigant decisions is crucial to a meaningful discourse on the nature and efficacy of legal mobilization and the use of courts to settle disputes. And so when we know more about this political condition and the effects of how institutions can vary across states, we can know more about why people sue more in one place than in another place. Thank you.
Our next presenter is Eric Helland from Claremont McKenna, who is going to talk to us about judges versus juries.
So thank you again for the invitation. I want to say I did something a little different than the other presenters in that The paper that I handed out is actually an excerpt from a book, but then I also included in these slides a lot of other stuff from the book. So with apologies, some of what you're going to see is in the larger book and not necessarily in what I handed out. Here's the basic question about juries, I think. And I won't go through this for sort of want of time, but we all know the sort of usual stories about juries. There's a claim that juries are, quite frankly, biased in favor of the plaintiff, governed by emotion, have a poor understanding of the law, are wildly unpredictable. And I could go on. You regularly find anecdotal evidence of problems with the jury system. I'll actually skip these quotes for want of time, but they basically say the same thing. Juries are sort of out of control. The argument that is less often made, but I think sort of common, is, well, judges would do better. So what we should do is that we should switch to a system where, in fact, we have judges deciding, because judges would be less likely to be swayed by emotion, more predictable, would more closely follow the principles of tort law, and so on. And I think it's worth noting that that kind of underlines a lot of the approach to tort reform we've seen, which is specifically you limit the discretion of the jury by putting caps on. You cap damages for pain and suffering because the argument is that juries need to have their discretion sort of limited. And in some sense, the argument for this is, well, we're about the only country that sort of regularly uses the jury system in sort of civil disputes. And so, in fact, we're a little anachronistic, and we ought to change that. Let me show you one piece of evidence to give you an idea of why this is such a tricky question. You're going to see this chart a lot over the next 12 hours, I promise. But this is sort of the rise in filings. Here's an interesting one that goes along with this, which is this is the decline in trials. And what you'll notice in this is jury trials are getting less and less common. So as filings are going up, we're using the jury system, but also, frankly, the bench trials as well, a lot less frequently. That is, cases are settling. So there's two reasons why that might be true. One argument is the Priest-Klein story that we were just talking about, which is, well, we all know what's going to happen, so why worry about it? Let's settle, because we know what the outcome is. The other is people are so afraid of juries that they're simply avoiding them, and so this is actually a problem with the jury system. Which one of these is right? I think that's a difficult question, and I would like to tell you that I would have a definitive answer at the end of my 10 minutes. I won't. I'll raise more questions. So let me ask you then, I want to sort of just call this the puzzle of the jury system. Here's the puzzle of the jury system. And I always hesitate to do this. Michelle Mello is in the audience, and I'm actually going to talk about her research. So watch and see if she begins to shake her head and see if I have this right. But there's a wonderful set of research coming out of Harvard right now that looks at revisiting trials, and particularly in medical malpractice cases. And what they've done is they've basically gone back, gotten an independent panel of experts to ask whether or not there was any negligence involved in this. And what's interesting is, and I'll show you just a little bit of evidence of this, their conclusion is the jury system does, depending on what you mean by pretty good, a pretty good job of sort of sorting these out. Now, most of these cases are settled, but they're settled in the shadow of the court system. And so what you see is, and this is stolen directly from their paper, if you look at these where there's actually an injury, and then you trace down, what you find is where these independent examiners think there's an error, compensation is much more likely. When the independent examiners think there's not an error, compensation is much less likely. And I should add a caveat that there's some other studies dealing with asbestos and product liability that reach different conclusions, but this sort of stands out as being sort of, well, the litigation system seems to do a pretty good job. But here's a troubling addendum to that. This is just a breakdown of awards per doctor around the country in 1999 to 2001. Now, what you'll see here is there's wide variation in the amount of awards. And this is actually true whether you decompose it by specialty and so on, which is an interesting question. So how is it that a system that does a pretty good job of figuring out whether someone has been the victim of a negligent injury compensates people in very, very different ways depending on where they happen to be, right? So what I want to do is, in the remaining time I have, which I suspect is about 2 minutes, then what I want to do is spend a little bit of time sort of looking at why is there this variation? And I want to give you 3 answers. These are not 3 answers designed to be comprehensive. They're just the 3 answers that I've studied over the years. And I want to just sort of use these as a topic for discussion. Now, unlike the book, I gave these wonderfully provocative names that I took from the popular press for the point of this to simulate discussion. But one is judges versus juries. Another is what Morley Schaefer wonderfully calls jackpot justice. And then the last is elected judges, which actually came up earlier. And I want to basically ask, how much of the sort of difference in awards can we explain through these things? Let's start with juries. I won't go into this again in much detail, but it's worth pointing out that if you just compare means of bench trials and trials decided by juries, judges award about 31% of the amount that juries award. And if you just look, lots of statistically significant differences. However, they decide very, very different cases. And once you take that into account, even before you control for selection, and I won't go into the discussion in the paper, you can explain about 63% of the difference in judges and juries. And in fact, what we do in this paper is we go through, and you can explain most of the difference in judges and juries. In fact, so much that we entitled the paper Runaway Judges with a question mark, because essentially we cannot find any large differences with one notable exception. And the one notable exception has to do with jury pools with higher rates of poverty. So I want to turn to that one. I'm going to skip this quote, but this is Morley Schaefer getting ratings. He calls it jackpot justice. And the argument is that there are these places around the country where juries are very, very sympathetic to plaintiffs. And basically the argument is that it's due to the poverty in the local area. Well, Alex Tabrock and I, my co-author on this study, went and looked, and based on a couple of different data sets, the state court awards, federal awards, and others, we actually find something that looks very similar to what was provocatively labeled jackpot justice, which is awards go up as the poverty rate in the jury pool of the local county goes up. Now, let me point out something. If we go back to sort of the standard sort of tort theory, if you think about it, this should go the other way. If there are poorer people being injured, you would think at sort of most you would find a decrease, right? Sort of greater compensation in areas that have less poverty because wealthier people are being injured. I'll skip this since I just got the 2-minute award. So here's the related graph, and this is, and I find this one perhaps more informative than the previous one. All of the effect of poverty is in product liability and medical malpractice. And in fact, really, if you want to be blunt, the vast majority of it is in product liability. Why is that? Well, think about this. If you believe that this is a vehicle for income redistribution, auto awards make a lousy way to do that. Max and I are both going to be paying higher auto insurance premiums if we spend time, if as jurors or judges we increase the awards. Less true for medical malpractice, although we would pay presumably higher prices for medical care. Product liability, that would be spread over the whole country. This represents an ideal vehicle for income redistribution. Well, I've got about 1 second left, so I'm going to skip over the elected judges because this was sort of talked about. And we have findings that are very consistent with yours. Higher awards against out-of-state plaintiffs and elected judges in states with elected judges. Let me then ask for the policy implications of this. What does this mean? Can these results be reconciled? That is, accurate judges and juries in medical malpractice cases, yet wide variation in awards, some of which is explained by things that, frankly, from the point of view of kind of conventional tort theory, we would think wouldn't matter. The poverty rate, whether the judge is elected, and so on. So here's my punchline. Variance appears to be caused by some judges and some juries, right? Juries that seem to be treating this as a vehicle for income redistribution, judges who face electoral constraints. What's my policy recommendation? Well, I don't have a policy recommendation per se. I have a request for further study. So here would be my policy implication. One of the things you'll notice about this is that the areas where we find the most variation, where we find it correlated with things that would trouble us from the point of view of compensation, tend to be those areas where people had a pre-existing relationship. So if I were to suggest an experiment I would like to see somebody do, I would like Paul Rubin up there in the corner to be appointed tort czar for some state for a 5-year period. And let's see what happens when we try to deal with this by contracts. Now, simultaneously, I'm a researcher. I'd also like Michelle to be appointed tort czar in another state. And let's look at the impact of different compensation schemes for people. If the system is accurate, let's see what happens. So I guess my plea for this, as always, is for further study, but I think it's interesting that our results seem to suggest, at least to me, that a lot of this has to do with the damage award stage of this, not the actual implications of negligence. And I'm about to get the yank, so I will stop talking. Thanks.
So let me introduce very quickly our distinguished panel, going from right to left. On my far right, in many ways, is Stephen B. Presser, the Raoul Berger Professor of Legal History here at Northwestern. Next to him is Robert S. Peck, the President for the Center for Constitutional Litigation. And then to my immediate right is Linda Kelly, the Vice President for Policy and Research at the U.S. Chamber Institute for Legal Reform. So why don't we go in reverse order, maybe for comments. So we'll start with you, Linda.
Sure.
And go on, and feel free to comment about one paper, all the papers, or what have you, and then we'll throw it open to the audience for questions.
Great, thank you. Well, thanks. I'm very pleased to be here today, and let me just start by telling you a little bit about the organization that I represent, so that will give you a good idea of the perspective that I'm bringing to the discussion. I'm with the United States Chamber of Commerce, which is the world's largest business federation. We have an underlying membership of about 3 million companies, and we represent every size and sector of company in the economy. Within the Chamber, I worked for a group that was formed in 1998 called the Institute for Legal
I
Reform.
think you have to speak up.
Oh, excuse me.
Sorry.
The Institute for Legal Reform was formed to address the tort crisis that is being discussed here as part of the program and the response to it. So I guess, at base I'm here to represent the perspective of the deep pocket folks who get sued. I'm going to comment a little bit on each of the 3 papers and then offer a couple of my own perspectives. First, I want to compliment all 3 of the papers. There's really a dearth of good data out there about what's going on in the tort system. Even the best source is data on federal filings. There's even, that's just a really small picture of what's going on, because most tort filings and tort litigation happen at the state level, and the National Center for State Courts has put together a data set, but it's incomplete, and there's just not much good data out there. On top of that, the filing information is just such a very small snapshot of what happens in the tort system. At the federal level, less than 2% of cases ever go to trial, and at the state level, I think it's closer to 1%. So looking at filing rates really tells you very little about what's going on in terms of decisions to settle and how those decisions are made. So I commend all of the authors for finding enough data to make some interesting conclusions. Also, going in reverse order, I'd like to comment on Eric Helland's paper first on judges versus juries. I think there's kind of a perception out there that the corporate community is anti-jury somehow, and I don't really think that's true. What we hear from our members is more of a concern about these so-called jackpot jurisdictions. It's not necessarily a concern about juries per se, so much as certain jurisdictions around the country where the perception is and the experience of our members is it's very difficult to get fair treatment if you're a defendant company. And I think that my favorite quote on this subject is from noted plaintiff's attorney Dickie Scruggs, who described these places as magic jurisdictions. And I'm quoting here, where the judiciary is elected with verdict money, trial lawyers have established relationships with judges, and they've got large populations of voters in on the deal. It's almost impossible to get a fair trial if you're a defendant in some of these places, no matter what the evidence or the law is. And so I think, as I say, it's not a fear of juries writ large, it's really a concern about treatment in certain particular jurisdictions. Based on a survey of corporate litigators that we do every year, some of the jurisdictions that they identify are Los Angeles, Beaumont, Texas, much of the state of West Virginia. For many years, there's been a lot of concern about Madison County, Illinois. Here, although there is a lot of evidence that things are changing there quite a bit. So I think this notion that the problem is sort of anti-defendant company jurisdictions really illustrates the problem more than that. There's an issue with juries. With respect to the second paper, I think it's certainly very plausible that the degree to which parties to litigation see the outcome of a case as predictable based on the judge and the jurisdiction. Obviously that's going to affect the propensity to settle or not settle the case rather than bringing it to litigation. I would expect that the professionalism of the judiciary in a jurisdiction would bring more predictability to it, and I think the paper suggests that there may be more predictability with elected judiciaries, so I was a little bit surprised by that finding. One issue I wanted to just sort of highlight there, the ideology of the citizenry in the state seems to be a very significant factor in the predictability of the outcome. And the conclusion seems to be that liberalism somehow increases the likelihood that a plaintiff will be able to prevail. I think maybe that it's a little bit too simplistic of a political analysis, and I'm just going to name a counterexample that I think illustrates that. If you look at a state like Vermont, which is very much a blue state, a very politically liberal state, which sent socialists to the United States Congress and now the Senate, you would expect that would be a litigation hotbed, and I think based on sort of a more I'll call it a cultural conservatism there. There's something about the people who live in that state that makes them less inclined to litigate. Contrast that with a state like Alabama, very much a red state, conservative citizenry, but a much higher propensity to use the court system to try to resolve disputes. So I don't know, maybe there needs to be a populism analysis worked into the model somehow. But I think this sort of culture of personal responsibility in a state also plays into the litigiousness of the people.
Can we hold the rest of
Sure.
your comments for maybe the audience participation session, just to make sure everybody gets a chance?
Sure.
So may I go on to Mr. Pack?
Well, thank you. It's been a pleasure reading these fascinating papers. I've got to say that the one that I was most intrigued with, the one that seemed to strike me as pursuing a very valuable ground, was Professor Jacobi's paper. It seems that our system of distributed powers, which is designed to make it harder to adopt public policy, and by doing so, making it go through these various crucibles, allow us to see the greater value that only articulates itself over time, is something that is interesting and I've never thought about in terms of its impact on litigation rates. So I found that an important way to look at it, and some of the institutional imperatives that lead people to courts that I thought were not discussed in your paper, but might be worth looking at, are two historic factors to begin with. Sort of the historical revulsion at legislative adjudication that took place during colonial times and early parts of our country's history, as well as the admiration for the heroic role that courts and juries played in our revolutionary mythology. So I think that there's this cultural inclination there. In addition, I think some of the current imperatives are the growth of a professional political class with little real-world experience and sort of a heavier reliance on lobbyists to supply the information. That, of course, to an individual litigant is not an entree point, and therefore they have to look to the courts. It's the scarcity of lawyers in legislatures. Lawyers used to dominate legislatures, and this is very much not the case anymore. And then there's the tendency to abdicate responsibility. I can't tell you how often in the course of my career I've had to go to Capitol Hill and explain the constitutional issue that some piece of legislation involved, and the response was, well, you know, that's not really my job, that's the courts to resolve. And so therefore they could have sort of a free ride by passing what they know to be unconstitutional legislation that they would never have to actually live under. I also think that you have to be very careful about defining a spectrum and saying that courts generally do not go outside that spectrum. I think the Warren Court was an example of spectrum shifting jurisprudence. You know, between Brown and Reynolds and Engel versus Vitale and Mapp and Miranda, we had the court operate outside, and suddenly the spectrum shifted because of the court's leadership, and the courts can lead. I think flag burning is a more modern example of that. So I do think you have to be careful, because courts have sort of a cultural belief that they have to do the right thing regardless of the consequences to themselves. And I think that generally overrides any self-survival sort of instincts. Moving on to Professor Yates' presentation and paper. This is the paper that most rubbed me the wrong way. This is the paper that I seem to rebel at thinking that this was a valuable road to go down. It seemed to me that, first of all, it overvalues the role of the judge and assumes too great an impact from the proclivities of an individual judge. You know, it's certainly not very true at trial, although maybe perhaps more so at the appellate level. Uncertainty in the outcome of a case, I think, is more of a function of the contrasting values that the plaintiff and defendant give to the case. If there is perfect information about all the information that might be proven at trial, you would think that those values converge, that they both think that this is a case worth X dollars, and as a result, those cases are most likely to settle. Where the information is more imperfect, where they have essentially grabbed different parts of the elephant and think that that's the whole elephant. That's when they really say, well, you know, we're going to have to go to trial to resolve this. And I think that, more than whatever happens from a judge, makes a difference. You know, you can try a case, judges can make all sorts of rulings, but in the end, it's the facts that have been proven that make the difference, and generally those facts will come out. I also thought that selection, you know, despite some high-profile races, particularly at the state Supreme Court level, most trial judges who have to run for election never really get much of a notice for what they've done in any particular individual case, even the most high-profile case that they try. It doesn't rise to the level of voter consciousness, and outside of a notorious criminal case, I think generally there are no consequences for those decisions at that trial level. So I think selection is probably far less important than it makes. And I also think the method of selection, elected versus appointed, really doesn't change judges. Principled individuals who have a point of view about what the job of judging is are not going to change because they've been elected or appointed. You know, we have the honor of having Chief Justice Taylor from Michigan here today. He was elected to that office, but if he were appointed to the federal appellate bench, I dare say that I don't think his approach to judging would change any. And so therefore, I think that that also overvalues the selection process. And one of the things that strikes me about this is, you know, at the Supreme Court level, the United States Supreme Court level, we talk about a freshman effect. A new justice appointed to that court tends to be somewhat tentative. tends to be a judicial minimalist, tends to follow the lead of a justice who they've admired for a long time before they sort of get their own footing and decide where to go. And over time, what you see from various decisions of different judges is that at some point they are in the job sufficiently long, they've seen enough cases of this kind or with these kinds of arguments or these types of lineups that they start doing something that they probably would not have done earlier in their career and tend to be more activist in the sense of putting their own personal views into their opinions. And I think that may be well true at the state level as well.
If you don't mind, may I move on to Professor Presser? We can come back to you if there's time for audience questions, but I want to make sure that we do have time for audience questions.
Thank you, Max.
And Steve, actually, if I could recommend, if you have comments specifically for Eric, since people have been going in order, maybe you could start with those and work back.
I won't. I'll have one comment a little bit later. I'm going to sum up a little bit.
Okay, that's great.
These are three very fascinating papers, and just as Bob said, and for me they were even more fascinating because I could only understand about 50% of each of them. But I'm not here really to explain the three papers. I'm not really a social scientist. I am, as Max said, a social conservative, and I am a legal historian, and I'm just going to try to put the three of them into a little bit of perspective. We can start with the basic point that brings us all here. We're in the midst of what Walter Olson, whom we'll hear from a little bit later, calls a litigation explosion. We're paying the tort tax, as the Wall Street Journal suggested the other day, of about $9,000 annually for a family of four. And this not only costs us a fortune that might be better spent, but it skews the expenditure of resources. So we seek to understand what caused this, and that's what we're doing, and indeed what we might do about it. Somehow I think it's appropriate to mention Grant Gilmore's famous statement of a while back, that the better the society, the less law there will be. In heaven, there will be no law, and the lion will lay down with the lamb. In hell, there will be nothing but law, and due process will be meticulously observed. In a good society, in other words, there's no need for litigation, and the better the society, the less of it you have, perhaps. So all this litigation we've got must be bad. Well, maybe not. Apparently, and this is the lesson of Tonja's paper, I think, with real humans, we're going to have disagreements, and we need a dispute resolution mechanism. I don't agree with Mark Galauner about the litigation explosion being overblown, but it is true that we've always been a litigious people. In Puritan Massachusetts in the early 17th century, for example, everybody habitually sued everybody else for everything. And if you read the court records from that 17th century period, it would just curl your hair. I think, in other words, it's something in our culture. And here again, Tonja is clearly onto something, suggesting that the problem is divided government. The government has trouble giving us what we need, so we go to the courts to get it. I'd go further. I can't test it empirically the way she's done, but I think one of our problems is that since we don't have an acknowledged social class structure, we don't have a state church, we don't have a monarchy, and we don't have an aristocracy, we have trouble figuring out what our values actually are, and so we thrash them out in the courts, since the only thing that we've got in common is the law. Not for nothing, then, do we say that ours is a government of laws, not men. Tonja takes the position that the problem is not the law, it's politics, and, to a certain extent, she's right. It should be said, though, and here, Max, I'll make a comment about Eric's paper, that if I understand correctly what Eric is saying, it is the judges are the problem, or maybe even better still, the law is the problem. And I think he's on to something, because I think the story that Marcia told us earlier this morning and what Bob calls spectrum shifting jurisprudence, the reshaping of legal doctrines, including products liability, medical malpractice, and equal protection, just to mention a few, by judges beginning with the Warren Court in the 50s and accelerating in the 1970s, 1980s, and 1990s, is a cultural problem. You remember, by the way, I hope some of you do, the wonderful movie where Hulk Hogan is playing a really, really tough guy, and a couple of obstreperous youths crash into his car, and Hulk gets out of the car, hulkingly shaking with fury. And the obstreperous youths get really, really worried, and they ask, "Are you going to beat us up?" And he says, "No, this is the 90s. I'm going to sue you." So this class action legislation and the popular notion of the lawsuit as a large-scale means of social redress are the products, I think, of conscious legal and political choice, a choice that we've got to consider undoing. And here I think the Yates-Tackersley Embrace paper underscores the point. If I understand their brilliant paper, and that's a big if, they indicate that professionalism of the courts encourages litigation, as does the method of judicial selection, but that the most important variable driving litigiousness is in fact the ideology of the citizenry, and that whether we're in a jurisdiction where liberals or conservatives prevail may be the most important thing to know. Linda doesn't agree, but I think I do. In other words, if you're in a jurisdiction where the prevailing ethos is, let's use the courts to effect redistribution, by God, that's what's going to happen. Now, what I draw from all of this, and I'm about to sum up, is that we're having the right conversation, but it ought to be a much broader one. And just to throw in something a little bit different, I wonder if the media has even begun to come close to informing the American people what's at stake here. Ultimately, the way you deal with a cultural problem like resort to the courts is, I think, education. But I suspect most of the public has little idea of how much our litigious culture costs them. Indeed, I think a bigger problem may be the manner in which the media has no real understanding of the economy itself, and further, how the media tend to paint us as haves and have-nots. In our era of finance capitalism, when virtually everyone directly or indirectly owns stock, through mutual funds, through pension funds, through participation in endowed universities, just to name a few. Some believe we now, all of us, all own the great corporations, and litigation against them hurts all of us. Tonja then is right when she indicates that we ought to look more at the connection between economic development and increases in litigation, but I think we need more carefully to rethink the ideological assumptions and maybe the cultural assumptions that we bring to these questions, and that's what we've been talking about.
Thank you. But I'm going to exercise my prerogative as moderator and ask the first question, and the question's for Professors Brace and Yates, and it's sort of a framing question. When I think of the Priest-Klein model, I think about selection for trial, not litigation rate. That may be an error on my part, but looking at your paper, I think you could posit that it's not uncertainty that's driving things, it's expected return from litigation gets you more litigation, right? And what you're really measuring with professionalism and liberalism are there different measures of how much you're going to get out of it and how likely you are to win, right? And so you could get the same results, couldn't you, even if certainty was unaffected by professionalism or liberalism, and it was simply the expected value of the lawsuit.
I think you bring up a good point. I think that Robert brought up in another passage earlier, and something I forgot to highlight, is the idea of where we are looking is very important to this whole interactive conditional relationship that we're positing. The idea is that certainty is going to turn on the ideology of underlying jury pools, public opinion, judges, etc. Because we're looking at something at this juncture that is essentially a plaintiff-dominated decision to file. That's not saying the defendants don't have anything to do with it. But if you were looking at the dominant action, it would be the plaintiff and their attorney in making the decision. If we were looking at trial rates, or number of trials per 100,000 people, I think it would be somewhat different, which is one reason we went back to this last one. I think there would have to be adjusted to consider the countervailing possibilities of defendants, double guessing. I'm thinking how this is going to come out, you're thinking. But here it is dominated by the plaintiff's decision-making process.
Okay. Kathy?
I have a question for Eric, which is just delving a little more into this county poverty rate and how you use it. It's clearer to me how that would be an interesting proxy for the composition of the jury pool, assuming the jury is coming from the relevant county. But to use it to sort of infer characteristics of the plaintiff and make the further claim about wealth distribution seems possibly like more of a stretch. So I was wondering.
So what we did, let me be clear. What we actually did was we looked at the poverty rate among those eligible for jury service, which varies a little bit. And you can actually bore down the census data to get a pretty good idea at the county level of the poverty rate, essentially among over 18 non-felons. This is essentially what we did. You're right, that is not the same thing as the poverty rate for all potential litigants in the county. That was going to be much broader. In fact, those numbers differ substantially. We did some stuff in the original paper, not so much in the book, to sort of look at that. And it really is the county jury poverty that matters in this. We don't really find any evidence of the overall poverty. And then actually there's a different paper that does a similar thing by Ted Eisenberg. He actually finds different results using the county poverty rate than we do with the jury pool poverty rate. So that's an important distinction.
Yes, sir.
I'm Kevin Conway. I've been a practitioner for 30 years, and it just seems to me there are two things that maybe just tangentially you touched on. To me, as a practitioner here and elsewhere, cases settle for two reasons. One is the look at risk, and the other one is the cost. Very little mention of cost. The risk, we know the risk much better now because disclosures are so much more demanding nowadays, okay? Everything has to be disclosed. If it's not disclosed, it's not in, okay? So that's how it's changed, and that's why things are settling so much more, period. And if you ask anybody here who practices in this area, they will tell you the same thing. Secondly, as far as why there's less litigation, conservative, liberal areas, it's really in the conservative areas, the access to the courts have been closed. Laws have been passed that prohibit you from filing. Either damages when they're reduced are such that the costs are too prohibitive to file the cases, one, or you can't file the cases because of statutes of repose, et cetera, okay? Onerous statutes of limitations, et cetera. That's why you can't file in those places. The same people are dying of the same diseases and the same things, but you know what? Access to the courts doesn't exist. That's the real difference. I know because I file them in all these states and I see, well, geez, you can't do it in this state because guess what? The law doesn't allow you. And again, if you ask practitioners in this room or elsewhere, that's what they will tell you. And I mean practitioners that do the filings. It's, you know, as far as certainty of the judges, I'll tell you, minor consideration, but it's certainly a consideration.
Hi, Ted Frank. I caution against empirical work that looks just at the state level. I think that ends up creating a lot of noise. If you look at Plano, Texas and Corpus Christi, Texas, and the model, it would predict the same result, but I think any practitioner would tell you that you could expect wildly different results in terms of access to justice or what the jury would be likely to do. Second, I'm concerned when the dependent variable is number of cases. Not only do what a individual cases changes over time, but I think when reformers or plaintiffs' lawyers talk about these issues, they're not so much interested in the number of cases, mostly because the number of cases is so dominated by the number of automobile accident cases, the smaller cases, that in itself creates a lot of noise. But in addition, the change in how aggregate litigation is used over time, the mixes cases has substantially changed.
Any panelists care to respond to these comments?
Yeah. I have a comment on the relative merits of doing state research. You have two sources of variation, actually, three. One would be year-to-year variation across states. You have interstate variation, and you have intrastate variation. Intrastate variation is still interesting, but so is interstate variation. And that you can explain differences in litigation rate between states, okay, the means between states. Doesn't mean what you're talking about is irrelevant, it's still there. But if the baseline mean between Texas and Alabama are systematically different, one may conclude that the systems in those states are driving those baseline differences. Okay? There may be idiosyncratic factors, such as poverty in Corpus Christi, that drive a different level of litigation in Corpus Christi than what you get in Dallas. Okay? But the overall litigation rates between the two states are different, and it may have more to do with the systemic differences between the two states. You can do both. And one doesn't indict the other. Or I'm having spent a considerable part of my life in the state of elusive. I'm real hesitant to think that isn't an appropriate way to understand difference. People living in urban areas.
Ronan?
Ronan, I'm from Northwestern.
First, I'm interested to see you guys sitting together, I mean, Jacobi and Yates, and because you seem to look at the elephant from different angles. You think that politics in the judiciary matters, and you think that politics in the legislative matters, and maybe both matter. But my question is to Eric, Helland. Have you controlled for tort reform? Because my sense is that tort reform will be negatively correlated with poverty, and then that may take away some of the interstate variation.
Short answer is yes, we did. Now, in the true confessions category, what we did not have your data at the time. This was research done several years ago. So on the to-do list is to go back and sort of see exactly that, which is as you and I know, these things come in waves. There's a big wave, and what I would love to know is that sort of driven by the same factors we're looking at here? Does some jurisdiction look, as if it's out of control, in quotes, right? And that leads the state legislature to pass a lot of reform. Haven't done that analysis yet. I think it's an interesting question.
Paul's been waiting, I think.
It seems like a lot of litigation is over what does a statute mean? What happens with it? So you're saying that when statutes are passed, that it would reduce litigation, I think, in your theory. But at least I know at the federal level, everybody always challenges new statutes, and so I wonder. And new statutes may create pre-kind sort of uncertainty. So I just wonder if that would really lead to reduced litigation or increased litigation.
Yeah, I talk a little bit more in detail about this in the paper than I had time to in the talk, but essentially, you can imagine legislation going either way. It could actually cause litigation, but to the extent that it achieves what it sets out to achieve, of bringing a new rule in and presumably resolving the problem, then you'd expect at least over time that it would reduce legislation, particularly the more detail it provides. The idea. So the closer we have to a code, the more likely we are to see less litigation being necessary because that detail is provided in legislation. So it's not just purely the sheer number of pieces of legislation passed. It's the fact that in divided government, there's literature on this about how empty some legislation is, how porous it is. And this has been studies done on how American legislation is more porous than other countries. And my suggestion is that the same effect's going on there. So it's not necessarily that we can count up the number of statutes and say, oh, look, government's doing its work. But it's the nature of those statutes and whether they actually go about providing the detail that resolves these conflicts, or do we still need to go to the courts to actually figure out what the legislation means?
Where you're from?
John Vale from the Center for Constitutional Litigation in D.C. Eric, is it an underlying hypothesis of your piece that similar injuries should be compensated in the same fashion from state to state?
So let me answer that in two ways. In the piece that I handed out, it's actually not required necessarily, right? There's not a normative implication. We were simply trying to document whether or not there was a difference in the way they were compensated. In the talk I gave, I guess that is, I would sort of say that, which is that I guess I would go one step further and ask, I'd like to know what the theory would be as to why if you lose an arm as a victim of medical malpractice, you're compensated differently than if you lose an arm as a victim of an auto accident. Now, I suppose you can sort of come up with some reasons why that might be the case, why it is more terrible to lose your arm in a medical misadventure than an auto accident. But again, to go back to what I think the professor was saying, I think that's a discussion we probably should have as to why it is that we think those differences are involved. The fact that they're there, I mean, I view my role as sort of documenting those differences.
I just comment back that I think I look at the law more as a humanity than the social science. And so there are huge cultural implications to the question, I think, that are worthy of fit. And I can say anecdotally, for example, Nebraska in 1977 put in a cap on all damages in medical malpractice. And it took a little over 20 years before there was a jury verdict that was more than the cap.
Professor Helland, you had a graph that indicated lower levels of verdicts in automobile cases.
Yes.
Then above that was medical malpractice, and then product liability.
It was actually the slopes. Right.
And I guess I just want to say real fast, you know, if you lose your left arm, and I'm a lawyer, it's disfiguring. If I'm a pianist, I'm out of business. But in my 35 years of practice, it's become crystal clear that medical malpractice and product liability cases are so difficult to bring, and I speak as a defense attorney, that the only cases that conceivably get through to a jury and then result in a verdict, which is also a relatively smaller number, by definition have to be the most serious. There is no product liability case or medical malpractice case where the damages are only $50,000 because it costs far in excess of that in cost and time to bring the case.
I think that's an excellent point. You know, I mean, one of the things actually Paul Rubin and I were talking about, there's this sort of robust finding that when states pass rules basically governing collateral sources, that what you find is actually the average award goes up. And this is fairly robust, that there's this increase, and as Paul and I were talking about, so my theory on this is actually that it's selection. That is if you basically have a collateral source rule in place that says, you know what, now you have to deduct medical expenses if you're competent some other way, that means that there's certain trials we're not going to see anymore. So I think that's potentially right. The one thing I would add to this, though, is with regards to poverty, that actually had to do with product liability cases being even higher in the case of higher poverty rates than in places where the poverty rates are lower. So I wouldn't make a lot of distinction between product liability, medical malpractice, and auto cases at the level. What I was sort of interested in was the slope. Why is it a greater compensation in areas with higher poverty? So I think your first point is absolutely right. I mean, when one of us in this room gets around to doing the study suggested, which is why are there these different compensations, I think one thing you would have to take into account is the limitations placed on ability to file and on the resources of the defendant, which I think acts as a deterrent in which cases get filed. Auto cases are fairly routine. You would expect more low-value, monetary value cases to be brought into the system the way you would in product liability. But I haven't done that study yet. I think it's an interesting one, and I'd like to.
Let me go to David Hyman.
Yeah, we actually in an earlier paper on Texas look at trends over time in size of awards and payouts, and we find smaller cases, this is now limited to medical malpractice, are disappearing from the system. So you have a change in the distribution of cases that are brought, I think largely because it just becomes harder and harder and more expensive to bring these complex medical malpractice cases. But that was just an observation. My question's actually for Eric because he got off easy and I actually wanted to push him a little bit on the poverty issue and just ask if you look first at different measures of poverty than one that you report. So I concede that the one you used is I think worth doing. I'm just wondering whether first a broader measure and also a measure that's a little bit different, like the conventional one is number of kids receiving subsidized lunches is a good measure of poverty in the area. And then the related point is, you point out in the paper, you wouldn't expect poverty to affect judges. And I guess I'd wonder about that a little bit because you might, statewide level, county level, expect differences in poverty level to influence the type or the way in which judges are selected.
Let me take your first question and then second. The first is, yeah, we did look at a couple different measures. It gets a little tricky in that we were trying to limit it to the jury pool. So in the paper, both the published version and the version of the book, we only reported the second, the measures of the county poverty rate because we could bore down and really get the jury pool. We looked at 80 families with dependent children. I think we looked at school lunch. And the other one that we actually looked at was we confined it to those over 65, under the argument that one, the poverty rate is much lower because of government policies, and two, they're much more likely to serve on a jury. And I have to tell you, I can't remember how all of those turned out, but I remember that we looked at them, I think it was footnoted in the sort of published version of the paper. On the second one, I think it's a very good point, and I haven't looked at it. I mean, I do think it's an interesting question. You know, we've talked about West Virginia here as, you know, West Virginia is just different than a lot of ways. You know, it's the second law of social science. It's different in the South, right? I think that sort of stands out, and no, we haven't really controlled for that. I think the mechanism by which this is going on, I think is still an open question. So it's a point well taken. Again, you know, in my to-do list of things, somebody should research that.
I just had some comments for Tonja. I think your hypothesis is just fascinating. I wasn't convinced that we can answer the question with the model you were using, and so I wondered if there might be some opportunities for further development. It seems to me the problem is just with the level of generality. Really what you're looking at is two separate relationships. First, when there is a high prevalence of social conflict on a particular topic, how responsive is the legislature to creating remedies for that? And the factors that you looked at in your model, I think, are probably indicative of that. You know that better than I do. But the second question is, when there is a law passed, what effect does it have on litigiousness? And that's really the harder question, I think, for the reasons that Paul was articulating, that, you know, there's all kinds of legislation out there, some of which is going to be designed to prompt litigation, like creating new statutory causes of action. Some of it's going to be designed to eliminate litigation by eliminating causes of action. And those are probably not so interesting to look at. But the interesting category, I think, is laws that just clarify the rules of engagement between, you know, buyers and sellers or other actors in the market, general regulations. So to pick case studies where we see laws like that coming across in a pattern across states and then look at the outcomes in terms of specific kinds of litigation, I think would be more powerful. But then to look at the first question of what's the responsiveness of the legislature to social conflict, I think it'd also be good to look for kind of natural experiments where we see a broad pattern of conflict in the courts across states that was responded to in different ways by different states over time. One example maybe is workplace injuries, where you had an enormous amount of litigation and an eventual move by all the states to a legislative, administrative solution, but really on very different time frames with very different battles in the individual state legislature. So I wonder whether that would be a way to test some of the micro-level hypotheses that are within your bigger theory.
I think I pretty much agree with everything that you've said. I think there's a lot more to be done here, and I see this as kind of a first run. I mean, and what I'm trying to do is trying to ascertain that there is a broad kind of relationship at a high level that we can talk about, and that really isn't something that other people have particularly looked at or thought of litigiousness in these terms. I think what you've described is a potential research agenda, you know, for someone over the next few years. I'm not sure if it's going to be mine, because as I said, this is not my primary area. This is just sort of, I'm interested in political structure, and this seems to me to be one of the effects of political structure. I think that, you know, case studies and all these different sorts of studies could be a way of getting in more detail at these effects and actually, you know, giving much more nuance to the overall conclusions. And I guess what I'm really trying to just get at is establishing these broad effects. And you know, maybe later I'll go and do some of the more minute sort of studies that you talk about. But I don't think they're at odds. I think that that's kind of secondary follow-up work, and I think that certainly would be a good way to go about doing it.
More questions?
Just a general question about the disappearing trial issue. That was one of our subtopics for this session, and we really haven't touched on a lot of it, some settlement issues. But there seems to be, I think the number you mentioned, Linda, was 2% of filings actually go to trial. And are there concerns about the consequences of that number, which I understand has been going down over time? And I think the Chamber's concerned about some of these issues, and Bob probably has something to say about it as well. Linda, what's your comment on that?
Sure. Thanks for the question, Henry. Yes, definitely a trend that we've been following is really the disappearance of trials, trials in the tort arena. And I don't have much more than anecdotal notions of what's causing it, but you know, the issues that we're looking at are tremendous pressures to settle based on one of the issues that I did touch on, fear of litigating in particular jurisdictions. Also, there seems to be a lot of concern over the cost of discovery, especially in the age of e-discovery. And I think, parties are using that to their advantage to try to, place additional pressures for settlement. Also, just a general fear of punitive damages and sort of unpredictable nature, a low frequency but high impact occurrence. So those are the issues we're looking at.
As to the disappearing trial, I think the danger there is that more and more of these disputes get settled essentially behind the curtain in private settings, and as a result, there's this impact on public policy. We don't have the transparency to see what types of issues ought to be addressed. We don't see what happens. It affects the distribution of cases that do find their way into the court system, and therefore gives us a skewed version of what is going on in court, and I think that's part of the danger here. As soon as we begin to generalize on the basis of what cases are in court, not knowing what other disputes are being resolved elsewhere, in what fashion, we also harm the organic nature of the common law.
I'll throw out another one now.
Paul had a question
Oh,
too.
I'm sorry. Go ahead.
Just a brief comment on the same issue is that my understanding is most business disputes are arbitrated, so they'd be totally outside of the universe of everything we're talking about. So that's another whole area of selection.
Max, one very brief comment. One of the things that I wondered when I was reading these papers, knowing about the incredible numbers of settlements that they are, is what kind of implications does that have for empirical research on the courts, period? I mean, how are you really going to be able to say meaningful things when, as Bob says, things are happening behind the curtain?
Right, and I mean, presumably cases can be settled without filing too, right? And this
Absolutely.
happens all the time,
Sure.
and that gets missed in all the data that we've talked about, especially when it's insurance companies to insurance companies, or their contractual disputes, which we are talking about here, but have arbitration provisions. And there's also state laws now that encourage arbitration in low-level tort cases, actually mandate arbitration in low-level tort cases, and if you reject the arbitrator's decision, right, you have to pay a fine of some sort. That's how it works in Illinois at present. So there's a lot that goes on behind the screen, and so the data are more selected than it seems. I think that trials are highly selected, we all know that, but even litigation levels themselves are, I think, increasingly selected because of arbitration, alternative dispute resolution mechanisms, and just the avoidance of all court costs by simply settling outside of the state. So.
Are we defining litigation as going to trial or being sued?
Well, actually, we should just ask the two panelists. Tonja, how did you define?
There are all these different levels that you can look at. When we're talking about litigiousness, you can talk about trials, you can talk about filings, you can talk about, just litigation-related activities such as settlement. And I think a lot of people use filings because it's easier in terms of the data. You can get the data, but also it makes sense. It certainly makes much more sense than looking at trials. Trials are rarities. They're when the system doesn't work, right? So it doesn't really make sense to look at trials. In terms of, I think that it's all filings are under-inclusive as well, in that there is probably a lot behind the curtain, but it's just very difficult to get at from a practical point of view. So you don't want to be. But I think you'd have to think of a reason why they are systematically biased in a way that's going to work against the question that you're looking at. So, to the extent that filings are under-inclusive and there's all these other things that are going on without anyone even actually filing, is that likely to be systematically related to the question that you're interested in? And so, so for me, is there a reason why this political effect that I'm talking about is going to determine which ones are settled before you even get to the point of filing it? I don't think so. So therefore, I feel confident that I can look at filings, and I think the same goes for the other data. So you just have to. I think what you use is going to depend on the question that you look at. But I think filings is a fairly a good compromise, though it doesn't capture everything. It's true.
I mean, another way of looking at this that has been looked at by Grossman and Surratt and others has been to use survey data and then literally ask people about disputes and the escalation of disputes. Did you seek an attorney? Did you file? Did you do a trial to hold all the way through? And that's a different way of looking at it. It may get at some of these issues, but there are different types of research and different types of questions.
And actually, we're going to see a data set from Professor Abraham, right, that's insurance payouts, which, do you know if your data set captures the payouts that would have been outside the court system?
Yeah, it does capture settlements, but only when the defendant lost.
Right.
It has its own
So it has its own selection issue.
we have
But if they didn't go to court or even file a suit but settled, nonetheless, you'd actually capture that. So all these data sets are pluses and minuses. So I think that was a great question actually to end on. So my understanding is we have a 15-minute break now, and we'll be back for the next panel. Thank you so much.